Namaste and Jai Hind. My name is Anand Narasimhan, and the endeavor in this edition will be to try and get the right perspective on important amendments that are being made to our penal code. It will now be called the Nyaya Sanhita, the Bhartiya Nyaya Sanhita, the Bhartiya Suraksha Sanhita and Nagrik Suraksha Sanhita and the Bhartiya Sakshya Sanhita. For many years, there has been a demand to go back and revise the laws that govern our penal codes or criminal laws. And more importantly, because some of these laws were dated as early as 1860 with some manifestations in the early 1900s. But in a Naya Bharat, do we need such old archaic laws, or does it have to have a new shape and a form? Now, interestingly, on the 9th of December, three of the bills that were presented, the draft that was presented after the bill presented in August 2023 was sent to the Parliamentary Standing Committee. That bills were suddenly withdrawn and a fresh draft was tabled in Parliament on the 12th of December. What are the contours of this Samhita? What are the kind of changes, amendments that we have seen? Let's try and understand that, and let's try and get a quick check on what these bills imply and mean. First up, let's try and understand what the new law is. The Indian Penal Code, or the IPC, now becomes the Bhartiya Nyaya Sanhita 2023. Changes, the most important and the key changes are that there are 356 sections that replace the 511 sections of the IPC. There are 175 sections now that have been amended, 8 have been added and 22 have actually been replaced. The other aspect is it reflects a very Bharatiya ethos, and the government claims in this bill that it is more justice oriented. Now, is that true, false? There are arguments to the counter and for it, so we'll discuss that in a bit. The other one that's also been introduced is the Bhartiya Nagrik Suraksha Sanhita, or the CrPC, Criminal Procedure Code. That's what the Nagrik Suraksha Sanhita replaces. The CrPC, Criminal Procedure Code 1898, is replaced with this bill. 533 sections that are replacing 478 sections of the erstwhile CrPC. 160 sections have seen changes, amendments. 9 have been added, 9 have been repealed. And it enhances citizens' protection. That's the claim, that's what it aims to do going forward in a Naya Bharat. The third bill is the Evidences Act, now replaced by the Bhartiya Sakshya Sanhita Bill 2023. Indian Evidence Act of 1872 gets replaced now. 170 sections, that is replacing 167 sections of the erstwhile IEA Evidences Act. 23 sections have been changed, 1 added, 5 have been repealed. It modernizes evidence presentation and interpretation. Let's try and get a little deeper into what are the significant changes and what it does. Now, some important aspects of the Bhartiya Nyaya Sanhita Bill 2023. First up, sedition. The word sedition and this aspect has been deleted. Secessionism, separatism, rebellion have all been penalized. Then the definition, how it says, acts against sovereignty, unity and integrity of India brought in. These are the words that have been brought in, or terms that have been brought in. Death penalty provision for gang rape of minors and mob lynching has been included. And in a first, community service has been introduced as one of the punishments for reform. Community service, wherein the court will decide what kind of service needs to be rendered, but there will be no proceeds or payment for the service that is rendered. So that's how it's being looked at. The key takeaways of the Bhartiya Nagrik Sakshya Bill, Suraksha Sanhita Bill, that let's try and understand that. Trial and judgment within 30 days of completion of arguments. Now, this has been made mandatory. Video recording of sexual assault victims should be made mandatory, and new provision for attachment of property and proceeds of crime. Some key changes or inclusions that have been made, takeaways. Now, in the Bhartiya Sakshya Bill 2023, the documents include digital records, emails, server logs and SMS. Also, computers, laptops, smartphones, locational proof has now been included as part of the Sakshya Bill. Sakshya is evidence. Now, case diary, FIR, charge sheet and judgment, there will be digitization done of all of them. And electronic or digital record shall have the same legal effect and validity of a physical record. Now, these are improvements based over time, technology, etc., which were not there in the old bills, and that's where These are the changes that have been made.
Hello, Moto.
All of these we will talk in great length. Our guest this evening, Anuja Kapoor, spokesperson of the BJP. She's also an advocate, counsellor, a rights activist. Vivek Srivastava is a left-leaning leader with political ambitions. But here as a political analyst with us, we have Sumit Chandar, advocate, and practices in the Honorable Supreme Court of our country. Sumit Nagpal, lawyer, former journalist, now for the last 8 years plying his wares in the top courts of our country. So namaste and Jai Hind to everybody. Thank you very, very much. So let me first understand from you, Sumit Chandarji, how would you see the second draft? A lot of corrections have been made. Some words which were used, mental illness, has been replaced with unsound mind. So those corrections changes have been made. Some textual errors, factual errors have also been changed. But this current draft that has now been tabled in Parliament, how would you see this? Is this a step forward or is this a step backward?
See, Anand, I'll go specific to the issues I think which still needs to be looked upon. I don't think there was any, first of all, requirement for creating an entire law. Our existing laws could have been amended. But for whatever reason, if a new law has come in, it has to now keep in mind certain aspects. Say, for example, Section 111, the 111, which earlier was 109 in the earlier bill of the same Bhartiya Sanhita. Now that talks about organized crimes, and the explanation in Section 111 uses the word economic offenses without a clear definition. Vague phrases such as financial scams, Ponzi schemes, mass marketing frauds, and there is no provision which defines or explicit definition of these terms. Now, if you look at the case of Shreya Singhal versus Union of India in the year 2015, where Supreme Court had held that Section 66A of the Information Technology Act was unconstitutional because it found the term grossly offensive, which was used in the IT Act, to be vague and devoid of precision. So now the new law cannot, again, after these judgments, also come up without defining vague and devoid of precision words. That needs to be looked into, and there are other aspects also. Say, for example, Section 377 of the old IPC, which of course everybody is aware with the Navtej Singh Johar judgment, was redefined by the Supreme Court, and the Supreme Court went into the removing the unconstitutionality qua the consensual sex. Now, that was just an interpretation of the section where the Supreme Court says consensual sex, if it is not there, then it will be, if it is there, then it will be unconstitutional for 377 to exist. But 377 also came up with other terms such as bestiality. There are several instances of bestiality in the country. Times of India in 2022 reported a case where a 28-year-old man was held for bestiality in Surajpur. Then again in 23 January, one man was held in Kollam, Kerala. One in June 23 recently in Bulandshahr, UP, a 65-year-old man was caught for bestiality. Now, the term bestiality was defined under Section 377. But now you remove the total entire Section 377 without applying the actual judgment of the case of Navtej Singh Johar. So these are the aspects that needs to be looked into in the new act.
Yeah, quite surprising that a man cannot be raped. Does the law of our country hold that a man cannot be raped? There won't be sodomy, bestiality, or a man cannot be forced upon. That thought process itself is a little, but there are certain other aspects where Supreme Court judgments have been respected with regard to adultery. But in this case, has it again should adultery be criminalized or not? That's another question. Or should there be a similar provision for both sexes? There was an argument, perhaps, if my memory serves me right, the Parliamentary Standing Committee had recommended saying that make it punishable on both sides, rather than just punishing only one gender. But they have removed it altogether. Anuja Kapoor, you would want to weigh in on this?
I think rather than criminalizing the one side and expect of it, because as Justice why do you decriminalize, and you take the women as a chastity of yours, which is definitely a very heavy statement, because when we are looking into the overall women empowerment, I think how do we talk about women empowerment is happening through the laws. A woman, you say, that can be empowered without a law, without she's been inclusive in a, as we talk on a Hindu Secession Act, suppose, the property, if we talk about. Now the woman is a part of a property. At first, she was not. So when we're talking about not only in now triple talaq, when we talk, this is women empowerment. We used to have a Muslim law and a Hindu law. Now the maintenance and the alimony is a form of it. As you very well know, Anandji, I'm also a criminal psychologist, a victimologist, and I've been serving as a Supreme Court lawyer. And I have also looked into matrimonial laws and criminal laws. So understanding the perspective very, very keenly in a very close arena. I have also fought for victim of crime related to acid attack. So if I see the whole scenario of it, we are looking for an inclusive society. We're going ahead with the well-being of the society, of the citizens of India. The Modi ji on 15th of August has said it from the Red Fort that we want to end the slavery. Now,
but
either we are
Anuja ji,
independent,
please, from your legal
or
acumen
we're not
and from your
independent.
legal
Yes.
understanding, please tell me, marriage is supposed to be a contract. So if
Not
anyone,
under Hindu law.
Huh.
Not under Hindu law.
Not in the Hindu law, but under the Special Marriages Act, it is deemed as a contract and it is part of the civil code, civil agreement. That's why it comes under the common civil code. What I am asking you is, if somebody breaches the contract, be it a man or woman, should they not be punished? Is it not a breach of trust? So then, should adultery be totally decriminalized? That's one argument. The other aspect is, you are saying that one gender cannot be raped at all. A man cannot be raped. So
Now, what you're talking about
that's
is,
what our Nyaya Sanhita now looks at. So is that a fair assessment by the lawmakers?
talking about, and now, as if we talk about, then we are talking about the same sex. That is how a man can be raped.
No.
So we're talking about.
No, it's not just same sex. If somebody is brutalized, the brutality can be in any manner. Now,
So
when
if-
that brutality
because
happens, it's very clearly defined for a woman, but it's not defined for a man. And you've totally
this is-
taken away that entire clause as Sumit Chandar mentioned. So I'm asking you, we'll get to the other aspects also with our other panelists in a bit. I'm just asking you. So how is this law equitable? If the law is only looking at women and not at men, how is it equitable?
Look, when we're talking about the equality of the law, I think if you remember, the Domestic Violence Act was only for the women. But now it is for men also, because I've filed many cruelty cases regarding
Correct.
the men more. Okay. But when we talk about cruelty, we're talking about rape. The incidences of the rape, as per FIR, how many do you see in this case? We talked about marital rape also. So when we talk about these things, we have to go as per the situation. We also talk about pedophiles. We also talk about many things in the society. So the inclusiveness is coming, where the first thing which we put forward is how a woman, she is the one who is mostly and brutally, the children and the women are the ones who are
isn't
brutally
the law
being.
of the country supposed to? I'm not against women being protected, ma'am, by the law, but isn't the law of the country supposed to protect any and every citizen, and equally so? That's one criticism. That's one criticism that comes as far as the draft of the BNS bill right now, and it's subject to amendment. The other aspect.
Anandji.
Yes.
Yeah,
please.
Anandji, because I think you understand what I'm saying, because this is a national TV. I cannot go in much of a details about a man, rape issues. I can only talk about this area is that, in rape, it is called as, if you finish one law, the other law which is connected to it also gets finished. We have to be careful in various areas that the laws retain, so that the connection
No,
between them
see,
stays. And if
sexual
we are
assault
talking
is
about
sexual assault. If
Supreme
a
Court,
person
no,
has been,
Supreme
if a
Court,
person is assaulted, if a person is assaulted against their will sexually, however it is, then that is should be deemed assault and should not be defined only for one gender in society. Is my argument, and I'm parking it there.
then
We
then,
got
then
other
the
we got
posh,
other aspects. We got other.
we have a posh also in the,
No,
in the,
we
then
got other
this is what
aspects to
I'm
cover.
saying. This
See,
is what I'm saying. There is a posh also in so how many, where all you will counter? So we're talking about posh also, which is
correct.
happening in sexual harassment.
The
and
Nyaya
posh, in
Sanhita, ma'am,
posh,
I am saying it's a, if one aspect of sexual assault is criminally punishable, then the other aspect of sexual assault should also be criminally punishable. Is my humble submission. I'm not saying please don't make it criminal and don't punish it, but the Nyaya Sanhita should have Nyaya for each and every citizen of the country, not gender specific Nyaya. That's what I am trying to say. Let's now also move to the other aspect, Vivek Srivastava and Sumit Nagpal. One of the arguments, Sumit Nagpal, is that this law or these laws, the new Nyaya Sanhitas, Suraksha Sanhita and the Nagrik Suraksha Sanhita and the Sakshya Sanhita, all of them only brutally empower the police and give them unbridled powers. Is that a fair criticism or not?
See, I would say that this would be wrong to say that these laws are brutally empowering police. You have to understand one thing, that on the one hand, you have got police, on the other hand, you have got judiciary. Every action of the police is subject to judicial review. So, you cannot say that police will be misusing the powers. I would say that whenever police makes an arrest, they have to follow the Supreme Court guidelines under DK Basu case. They have to produce before the magistrate within 24 hours. So, whatever action police will take, it will be subject to judicial scrutiny. And if the judiciary finds that, if the courts find that the police is using excessive power, one, the FIR can be quashed. The High Court has the power to quash the FIRs. The magistrate can discharge people. And I can say that these laws were required as per the new realities of life. We had seen new offences like terrorism. It has been introduced in this particular law. Earlier, IPC did not deal with it specifically. We had a different law, like we had POTA, we had TADA. But now these laws are covering that. And as far as the development of internet is concerned, so all these things, it's so difficult to prove electronic evidence in the court.
Police remand dimensions from 15 days to up to 90 days. Up to 90 days.
Yes,
yeah. So
yes.
Vivek Srivastava, you agree, disagree with?
See, very clearly, being an activist, I'm an engineer by qualification, but my activism mein hu, we protest, we have sit-ins, we speak against the government. So the first thing when this thing was introduced, Anand, today, and I was reading the whole lot, it was from the perspective of an activist. I mean, this is full of clauses which can be used to just have a state control of the people. That is what it is. 15 days ka remand tha. Now you are saying we are extending it to 60 days and maybe to 90 days if needed. That's the first part.
But the court will decide.
No.
The court will decide whether the remand has to be given or not.
In this country,
the police cannot go and take remand.
In a remote area of UP, Uttar Pradesh, Northeast, आप जाएंगे, sir, daroga दूर की बात है. Even a simple constable is a king in himself. You forget about this. People are lost illegally in jails. People die in jails. This is the condition, and we have to be realistic when we make laws. And a lot of activists are raising this point that you have given the police too much of power, which can be misused in the custody. Number one. Number two, the terrorist word. See, there are a lot of loose words they have used. I mean, as rightly reported in your packaging that you had used in your program. Yes, sedition word has been removed, but there are many more which they have changed the words. But the control and the punishments and the harassment is much more. You have to understand, we are a very poor country. We have a system which is not in place at times, and the protest is the only way there.
Make his point.
This is not a poor country.
Let him make his point. Let him make his point. There are two sides to it. Let him make his point and then please counter.
See, first of all, a new word. Petty organized crime, ये लेकर के आए हैं, whatever is that. उसमें snatching आ रही है, a lot of other things are coming into picture. Then they are saying, at least a superintendent of police level officer has to be there, and then he is going to register it out. They have not laid down and written the basis on which the case will be registered. It is still very ambiguous. There are a lot of loose ends. And anyone the government
See,
wants.
at least there is clarity that economic offenders are not going to be handcuffed. One aspect. Second, petty organized crime and organized crime, there is a dimension that's been changed. So, a group of chain snatchers in an area cannot be bunched with organized crime. The third part, what Sumit Nagpal just now said, the court will decide if there is to be extra police custody, and there are cases under which the court will decide there is extra police custody. With respect to are we a poor nation or not, if you look at as per capita income, we will be considered poor. If you look at as GDP, we are among the top 3 economies in the world. So that argument will continue because we are a nation of 1.4 billion people. So to get to about $15,000 per head, it will take some time, ma'am, Mr. Vivek Srivastava. But today, don't our police personnel also need a certain level of power to crack down on the type of crime that we are saying? Sumit Chandraji, what would you say?
The power to the police, Section 41 CrPC was expounded upon by the Supreme Court in the Arnesh Kumar judgment, which is extensively followed. Now, Section 41 CrPC now, despite being expounded upon, leaves it to the interpretation because there is no CrPC at all. So now it will be whether the provisions, which provisions of the which act is going to apply, which will be parallel to Section 41. Secondly, a lot of other acts rely upon the Indian Penal Code, for example. Say Section 54 Juvenile Justice Act says kidnapping and abduction of child. For the purposes of this act, the provisions of Section 359 or Section 369 of IPC will apply. But now the new bill's last section itself is 358. I think the entire confusion is now going to come up with respect to which provision is to be followed, whether the Supreme Court, which has actually expounded upon the various provisions of the IPC, CrPC in various cases, now what happens to those, and whether now the new act, what provision will the expounded provision, whether it has covered all the provisions given by the Supreme Court, has been covered under the new act or not, is to be seen.
Sumit Nagpal?
I would say that every law is subject to interpretation by the courts, and when it comes to applying the new laws, obviously the court will see the content, the nature of the offence, and they will compare it with the earlier judgment given in a particular case. To be very frank, the section is not relevant. What is relevant is the nature of the offence, the interpretation given by the Supreme Court. So, the nature of the offence, it is covered by the new law. The old interpretation will be applied by the courts. I don't think there would be any problem. Obviously, I agree to one point that so many laws will have to be amended because those laws are talking about Indian Penal Code. So, these laws will also be amended in the due course of time. But I don't think there would be much problem. But yes, people are used to these laws and it will take time to get used to the new laws. It will take time. I do agree on this aspect. But as far as the interpretation is concerned, the police will see the nature of the offence, the magistrates, the judiciary, everyone will see the nature of the offence, and on the basis of that, the cases will be decided.
So, I mean, Anand, from what I can make out, the police is becoming a very, very important tool to be used by the state to control. For example, terrorism. Now, if you read this whole the new laws that they have introduced regarding terrorism, terrorism is a very broad word. Separatism, बहुत broad word है. What comes under separatism, what does not. If I discuss with you something in debate and I talk about something.
Why don't you ask the same question for the word minority as it's defined in our constitution? It's a very broad word. It's not defined and it's been debased and abused to a level. Why don't you ask for the name secular and the meaning of secular and how it's been debased and how broad the ambit is? How is 20% of our population minority, 2% of our population, 3%? What minority is? So where it is convenient, you want proper definition. Where it is inconvenient, you don't want any definition because it suits your political motives.
It's not that.
The point is, my friend is completely discarding the role of the courts, that police will be doing everything, whatever is possible for them under the law. Ultimately, they are responsible. They have to show their faces to the judges. The judge will ask how you have done
I have to wind up, but largely there are certain areas which are causes for concern, and let's hope it's debated properly and raised in Parliament and the amendments are brought in. One aspect is Nyaya has to be equal. Nyaya has to look at and take care of the interest of every citizen of the country. So it should be gender neutral and not gender specific. One. Secondly, ma'am, and to all our panelists, the fact is that the cops or police needs to be empowered. The other aspect is that those who are accused and their defense and their criminal lawyers should not be able to get tariq pe tariq. Somewhere there is an effort to try and curb that and to also give time to our courts and empower our courts. moving the word judicial magistrate and replacing that with magistrate somewhere also helps. So there are a lot of pluses here in the new Nyaya Sanhitas or the new criminal bills, but there could be improvements.
And one thing,
let's hope it's debated fairly in Parliament compared to this nice polished debate that we have. Let's hope it's an elevated one in Parliament when the debate is when the bills are finally discussed. I thank all our panelists. Thank you very much. I've run out of time. Thank you very, very much. Namaste.